Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Well, back to my Black Santa example. Suppose it's a state that defines public accommodation, prohibits a public accommodation to discriminate on the basis of political ideology. So then the picture has to be taken.
I think that is likely. Those political ideology distinctions face much more difficult constitutional scrutiny, and I think are separate in kind from the kind of characteristics that we're talking about here, which are categories of invidious discrimination. I candidly think in most circumstances, political ideology did not satisfy the constitutional requirements.
So it has to satisfy a constitutional requirement? Your argument is dependent on that?
Yes. Because even under O'Brien, we have to show a basis for what we're doing.
In light of what Justice Kennedy wrote in Obergefell about honorable people who object to same-sex marriage, do you think it's fair to equate opposition to same-sex marriage with opposition to interracial marriage?
Yes, because in how the law applies, not in discussion with folks, because of course honorable people have different views on this issue. But I think when you look at what Justice Kennedy said there, the way to honor that requirement is, as this court has set forth in Fulton, in Masterpiece, of having a rigorous interrogation to make sure that there are neutral and generally applicable laws applied in fact that way, that don't single out religion. And then the very next sentence of what Justice Kennedy said in Obergefell talked about when it transformed that honest and decent disagreement transformed into enacted law and policy, the necessary consequence is to put the imprimatur of the state on that exclusion. And I think if this court were to say that the imprimatur of this court would allow a web designer to say no same-sex people allowed, or allow a school photographer to say no pictures of.
Do you think Justice Kennedy would have said that that it's honorable to discriminate on the basis of race?
No, I don't think so.
Let me just give you one more hypothetical. Suppose someone offers the service of writing customized wedding vows or customized speeches to be given at a wedding by people who have an idea what they would like to say about a family member or a good friend, but they just don't feel they're very good with words. They can't put it into words. And let's say this outfit is just starting up. They don't have a lot of clients. They're sitting they're sitting by the phone and their computer waiting for somebody to show up. So they will take anybody. All right. Can they be forced to write vows or speeches that espouse things they loathe?
No, they cannot be forced to write vows or speeches that espouse things they loathe, because that's not a protected characteristic. But they cannot, I assume in your example.
Well, is the prohibition or the limitation against compelled speech limited to things that are unconstitutional?
No, I think there are.
So why does it matter?
Well, because here, things they loathe is not a protected characteristic anywhere that I know of, but on the constitutional.
Okay, it doesn't fall within. You say it doesn't fall within your statute, but maybe it's going to fall within the statute. It may fall within another statute.
Under any level of scrutiny here, you look at the state's compelling interest in determining the incidental burden on in our example, the vow writer's rights, and I don't know of any state that has sort of a compelled, has the same compelling interest as they do for protecting things that other people loathe as they do for sex, gender, religion discrimination. So I think it would be a different analysis.